Once again, hello there, everyday Americans. Paul Engle here with the Constitution Study. Actually, let me make sure my stuff is recording because this is supposed to be, where's the, oh yeah, I am recording. Excellent. Okay. Hello, once again, everyday Americans. Paul Engle here with the Constitution Study. I am glad you could join me. For those of you who hung around while I had my little technical difficulties, thank you very, very, very much. I know sometimes these can be difficult. They can be annoying, but I'm glad you could join me. As always, you know, if you have any questions, if you have any ideas, any comments, please put them in the chat or in the comments. Everybody who's on Zoom, you can be in the chat. If you're willing, when you have your question, we can actually unmute you and have an actual conversation. I think that'd be pretty nice. For those of you on YouTube or on the website, you can just put in your comment. I will get notified and I will try to answer them. We've got some interesting stuff going on. I just got back from an interview that is kind of related to what we're going to talk about, but all in all, we're having a grand old time. I'm just going to see if I can change that up a little bit. There we go. And I have kind of a, well, I don't know if this is an interesting topic. It certainly has been an annoying topic for a while. Many of you who follow me on Facebook may be wondering what happened. One person thought I had been abducted by aliens. No, I have not been abducted by aliens. I have been banned by Facebook. Some part of me thinks that's a rite of passage, some, you know, a badge of honor. Some of me just thinks it's annoying. So let me tell you a little bit of what's been going on and why I titled this particular episode, Ministries of Truth. So I've been on Facebook for a while. I mean, I've been like 2 years. I've been posting stuff on Facebook. And about a month ago, a little over a month ago, I got a notice that I was going to be blocked from posting on Facebook because I supposedly violated some community standard. Now, they said, if you think this is an error, click this link and, you know, you can, we'll have it reviewed. Except every time I clicked the link and filled out the form, they said, sorry, we cannot process that at this time. I thought that was a lot. But after about 5 or 6 days of trying, I gave up and said, well, okay, I'll just wait till my 30 days are up and I'll just flood Facebook with all the stuff I've been saving since then. Then just as those 30 days was about to be up, I logged into Facebook and got a very interesting message. It said, by the way, it said that my account had been disabled. Again, because according to them, I violated some community standard. And once again, they said, well, if you think this is an error, click this link and it can be, and we'll have it reviewed. So I clicked the link and it filled out the form and it said, oh, by the way, you have been banned because of a violation of our community standards. This is not renewable. Now, I'm kind of a, you know, I can be a little fiery sometimes, but I'm a reasonable person. If I did something wrong, if I did something that violated a documented community standard, fine, tell me what it is and I won't do it again. Well, except they won't. They won't even tell me what it is I supposedly did. Now, I decided to take a few days, kind of calm down, think about it, collect myself, and I figure either it's possible I actually violated some standard. I mean, I have been posting information about what the Constitution says about the presidential election process. And we all know how Facebook feels about truth when it comes to the election. So, you know, maybe that was it. Maybe, you know, they just decided they didn't like the fact that I was doing that, and that's why they banned me for 30 days. But then I thought, well, maybe it's one of the groups that I'm in. I'm in several groups. Maybe one of those groups did something that violated a standard, and that's what got me booted, because I was admin on several different pages and groups. I thought that was odd because, again, what did I do wrong? And then I was wondering, well, could it be just some troll ratted me out for something I didn't actually do? That's quite possible. I mean, I've had this before. I've had material. I got I had a post taken down because they said I had copyrighted information on it. And they said it was this video at this time, to which I responded going, that's a video of me standing in front of an image of the Constitution, reciting it verbatim. What is copyrighted about that? And a couple days later, they released it. I'm used to that. So at this point, I have no access. I have no admin to the page on Facebook. That account is dead. I can't do anything with it, and Facebook won't even tell me what I did. So I decided to take a few days and figure out what I was going to do. And that's where this idea of the Ministries of Truth came to me. So let me tell you a little bit about the Ministries of Truth, and then we'll talk a little bit about what plans I have for the Constitution study post Facebook. So hopefully everyone's here familiar with the George Orwell's book 1984. A very dystopian book about a potential future which, by the way, resembles an awful lot America today. See, in his book, the government had a ministry whose purpose was to keep the people uninformed, misinformed, confused, deceived, and directed where they wanted. This ministry was called the Ministry of Truth. Today, we have our own ministries of truth, only they're not run by government. They're run by private companies. Facebook, Twitter, Google, these are the new ministries of truth. And if you look at what they've been doing, and I've got some links I've brought up to remind me of some of the things that has been happening at these, well, mostly at Facebook and Twitter, but I've seen a lot of it at Google as well. But all attempts to keep the people uninformed, misinformed, confused, deceived, and directed in the direction they want. Now, let me deal with uninformed first, because that's a lot of people talk about Facebook and Facebook fact checkers. A lot of the pages I dealt with, I'd get a notice that some posts had been fact checked and found false. Now, I don't know about you, but whenever somebody looks at me and says, I think that is false, I go in to check what it is because I often don't believe it. I see a lot of, it's like, well, so-and-so said that this person never said that, even though they actually had the video of the person saying that. Or, well, this didn't really, or this was out of context. You know what? I had a question in here. So the lies of omission. Right? You got to remember that. Lies are not simply telling something wrong. You can have a lie of omission where you aren't told something. Now, I couldn't track it down in time for this show, but there's been a report out that some group did a survey, and they were asking people if they had heard about the issues with Joe and Hunter Biden, if they were aware of that. And a shockingly large percentage said no. Then they asked those who had not, they said, if you had learned about this, would it have impacted your choice in the presidential election? And something on the order of 60% said, yes. People's Republic of Maryland. Yeah, we're going to have fun today. So, what we see is people have become uninformed because, well, Facebook, Twitter, the news media, they simply don't tell you. What you don't know, they say what you don't know can't hurt you. No, it's what you don't know really can hurt you. Of course, it's what you do know that's just not true that really gets you in trouble, which is the next part, misinformed. It's when a fact checker says, oh, there's a fact here, and well, no, that's not really true, but you can get into a lot of, it makes you make really bad decisions. So we've got these ministries of truth that are leaving us uninformed, misinformed, confused, deceived, and most importantly, directed the way they want. So let me take a look at, I want to bring up some of these headlines. These are all headlines I've pulled over the last, couple of weeks. Let's see. We got from Patriotising. Facebook fact checkers caught making wrong fact checks. Well, what goes a fact checker if they're checking the wrong facts or their fact checking is wrong? Let's see, what else we got here? Facebook admits to censoring conservatives. Facebook blatant censorship of political speech. Facebook deleting coronavirus posts leading to charges of censorship. Are we sensing a theme here? Let's see. Facebook and Twitter cross a line far more dangerous than what they censor. Facebook announces political censorship plan in advance of the U.S. presidential elections. I believe this may be the one that I triggered. See, if they looked at their algorithm and said anybody that mentions election, we're just going to block them. Not take down the post. We decided, or maybe they look at the post and they derate the post, and I don't know. They won't tell me. Let's see what other goodies in here. Facebook blocks 120,000 posts in fight against political misinformation. Oh, shut up. I hate when they believe. I avoid playing videos automatically because they're annoying. But, you know, here Facebook says we're going to fight election misinformation. Well, misinformation defined by who? See, if it was truly misinformation, that would be something that's factually inaccurate. Should Facebook be blocking things that are factually inaccurate? I think that's not the most effective thing to do. You see, if someone has a fact that is factually inaccurate, but they never get challenged on it, they can never learn. So I said, if I actually violated a Facebook community standard and I don't know about it, I can never change my behavior. But the sad thing is, what defines election misinformation? Does the fact that Joe Biden got up and did a press conference in front of a fake seal for the fake office of the president-elect of the United States? There is no office. In fact, the president hasn't even been elected yet. The actual presidential election doesn't happen until December 14th, and the count for that election doesn't happen until January 6th. But you see, that's what the Constitution says, and that's what federal law says. But you see, according to many on Facebook and Twitter and on the blogosphere, that's misinformation. But it was actually Joe Biden that was posting misinformation. Let's see, what else we got floating around in here? Facebook censoring conservatives again. Oh, here's another one. I love this one. YouTube to delete, this is new, YouTube to delete content alleging presidential election fraud. So apparently, if you have evidence that there could have been election fraud, that either there was election fraud or is suspicious of election fraud, or even apparently question the fact that Joe Biden may not have won all the electorates he's been awarded, then YouTube is going to censor, said they're going to delete your content. I find this very interesting because I've seen lots of content awarding Joe Biden electors that hadn't even been certified yet. You had states where they're basically doing this on what the media said. To me, that's misinformation. Is that going to be what gets purged from YouTube, or is it going to be me pointing out that a presidential election hasn't even happened yet? I don't know. This is getting crazy. Then we have the Lincoln Project apparently is out trying to the Lincoln Project's out. I guess they're trying to work on the presidential election, and there are I don't know, there's some lawsuit with it. It's just more craziness, and this concerns me. Not so much because of what Twitter and Facebook and YouTube and Google are doing. Twitter and Facebook and YouTube and Google are privately owned companies. If they want to set their standard for community guidelines, they're more than welcome to. If they want to restrict what content is shown on the platforms they own, they are welcome to. They are legally allowed to. I do not contend with Facebook's legal authority to block my content, to disable my account. My concern is that if they do so without any redress of grievance, well, that's unethical. we had an agreement, Facebook and I, when I signed up, and I signed up for the terms of service, and I have to admit, I didn't read all the fine print, but if I don't have the ability to even get a redress, to even have someone look and say, yeah, here's what you did. I mean, if I truly did something wrong, they should be able to go, okay, on this date, you had this post and you said that. And that violates this article, this clause, whatever, of our community standards. If that's true, that's all they have to do. Here you go, Mr. Engel. Here's the post that you posted. Here's the community standard that it violated. Here's the comment that you made. Here's the community standard that it violated. And okay, I'll take my punishment. But you see, they won't even do that. The Ministries of Truth are now not only twisting information, they're restricting information. But here's the thing. A lot of people are trying to get the federal government to break them up or to put in laws and rules. The problem isn't with Facebook. It isn't with Twitter. It isn't with YouTube. It isn't with CBS, NBC, CBS, Fox, MSNBC, CNN. The problem is not with them. They have problems. The problem is the American people are listening to the Ministries of Truth. They are listening to propaganda. And kind of like being caught in the matrix, they don't realize that they're being lied to day in and day out. They're being misinformed. They're being led to think a certain way because that's what these ministries are for. So that's what's been going on with the Constitution study. By the way, I have made plans for this eventuality. And I'm going to recommend that people consider some of these things. First of all, if you want to follow the Constitution study, the best place to follow it is the website constitutionstudy.com. Now, granted, yes, I'm on a hosting service, and it's theoretically possible that hosting service will one day disable me. I'll go to another hosting service, or I'll host it myself somewhere. I've got the technology, I've got the capabilities to do that. But the nice thing is, I don't censor myself. So constitutionstudy.com, you can get all the articles, you can get all the videos, you can find everything there, and that's the best place. But I'm still on YouTube. For now, YouTube has not blocked me. Twitter has not banned me. I'm on Parler. I'm on Rumble. I'm considering MeWe. I've heard several people say some good things about it, and I don't know. I'm not sure yet. For some reason, it just hasn't. It just hasn't seemed right. But I'm still looking at it. But I'm also making some plans for next year. I'm going to talk about a little bit later that hopefully everyone here will find really, really interesting. So if you have examples, first of all, again, everybody, if you've got questions, put them in the comments. If you're on the Zoom, unmute yourself, ask your question. I may ask you to, I may take a moment to get to your thing. YouTube is not live. Someone says YouTube is not live streaming my meeting. You know, I'm really getting, again, maybe they found out I mentioned the election and they're after me already. Who knows? Let's see. I'll get a look at YouTube. Hey, Daniel, have you got something to say?
Yes, Paul. What would happen if we have been looking at the Declaration and the Constitution in a completely wrong context? I say this because as I was going through a 1756 dictionary, I stumbled on the word corporation. And it says corporation is a body politic, and politics is defined as the science of government. So if we start looking at the Declaration and the Constitution as corporate documents, the Declaration being our proof of ownership, and the Constitution being the bylaws, then wouldn't all of our voting criteria be defined in the corporate charter, the Declaration, and not the Constitution and such?
Well, I've heard that argument, and I've even used that as a description. I use that in the book as a way of understanding the difference between the Declaration and the Constitution. The Declaration, if you've ever incorporated, if you ever set up a 501c3 or anything like that, you have what are called letters of incorporation. Your intent to create this new entity. And that's probably the best description of the Declaration of Independence. It is legally what it is the 13 states under English law giving the justification for them separating from the mother country. And that's like the Constitution. Bylaws is a good example of it, but remember, it is the bylaws for the central government, for the union, not for the individual states. So, when we look at it saying, that's what, do you realize there is only one federal election in the entire country? That's the one.
President.
Actually, yes, yeah, it's when the electors vote for president.
Yep.
Right. So November 3rd were all state elections. There was not a national election held on November 3rd. Those are all state elections. December 14th, when the electors meet in their states and they cast their votes, that is the only federal election. That gets counted on January 6th. But I look at it this way. Article 6, Clause 2 says the Constitution is the supreme law of the land. It is law, and it needs to be treated as law. Too often, though, it seems to be treated as a plaything, a nice idea.
Isn't that the first of four elements of the supreme law of the land? The Constitution, then the laws made. The Constitution, then the laws made in pursuance thereof, the treaties made,
yes,
or shall be made under the authority of the United States of America. But most people don't recognize the difference between the Constitution and the Declaration and those four elements.
Well, you have, again, the Declaration is not law. The Declaration is the justification, the public justification for the separation from the mother country. In the Constitution, Article 6, Clause 2 says, this Constitution and the laws of the United States made pursuant thereof, which is why only federal law made pursuant to the Constitution is also supreme law of the land. And treaties made within the powers of the United States. So only treaties made that actually are a power of the United States are considered supreme. Right, so you've got those things, but what's interesting is federal law and treaties still are subservient to the Constitution because they must be made pursuant to the Constitution and the powers it delegates to the United States. So, a treaty that says infringes on your right to free speech. Let's say they decide to create an international hate crime law. Or an international blasphemy law. That's not a valid treaty. It's not the supreme law of the land of the United States because the federal government, the United States, does not have the power to impose that sort of law. The government cannot do by treaty what it cannot do by law. So,
all right.
Right?
So I guess when I'm getting back to the corporate documents concept, if you and I are to create a corporation, it's that contract that you and I make that becomes our most important document, and then the bylaws with respect to how we're going to control that government. That document that you say is not law is our proof of ownership over our governments and how we're supposed to control it. When it says governments derive their just power from the consent of the governed, we, yes, as the governed, are the owners of government.
So to me, it's not. That is one of many things the Declaration of Independence says. In fact, if you take some time and you look at the grievances listed, there's 27 grievances listed in the Declaration, you'll find a restriction on the government in the Constitution that matches that. So the letters, it's the letters of incorporation are not legally binding on the corporation, right? It's the bylaws that are legally binding on the corporation. So yes, the compact, the Constitution is a compact. It's an agreement between sovereigns. In this case, those sovereigns are the states. That is the legally binding contract. When the Declaration says that governments are created to protect our rights, that is its sole, they talk about compelling government interest. The primary compelling government interest is to protect our rights. not to protect us, to protect our rights. And that we institute governments, and they get their just powers from the consent of the government, from the consent of the governed. Well, okay, the government works for us. They are supposed to be public servants, not public masters. That's an important concept. That they have just powers, but it doesn't, if you have a just power, then there's got to be an unjust power. Now, unjust powers need to be punished, but yes, they get their just powers from the consent of the governed. The question is, how do the governed give consent? See, we all think that consent is going into the voting booth. Our consent is when we consented to create states, and those states consented to create a government. We put rules around that government. We put barriers. We put boundaries around that government. And part of our consent is we consent to who will represent us. We consent by voting, and we consent by not voting. If you don't vote, you simply consent to someone else choosing for you. To take the corporation.
I beg to differ.
Well, no. Think of it this way: if you have if you own stock, you get a letter that says there's a shareholders meeting and there's a vote coming up. If you don't vote, you effectively give your vote, you proxy your vote to someone else. If you don't participate, you consent to letting someone else choose for you.
The 1756 definition for consent is the act of consenting, an agreement, an accord. And if you have a known body of voters, such as registered voters, then to get that body's consent, you have to pass the 50% mark of the total number. Without that 50% mark, you have not received the consent of that voting body's majority.
But again, if I have the right to vote and I choose not to, I've effectively consented to let someone else choose. That's why people who say, I don't vote because it doesn't matter, you're consenting to let someone else decide. If we go back to the corporation, if only 40% of the people of the stocks issued actually vote, those 40% get to choose, because they are unless there's a quorum requirement in any of the voting, which, by the way, there's no legal quorum requirement for a vote in a state office or for a state election. So you're back to the not voting is voting. It's just voting. It's not even none of the above. It's the I'll let someone else choose. But that's kind of off topic from where we're talking today.
Yeah, I'll leave it as we will disagree on that.
That's fine. Hey, you know what? Differing opinions are a good idea. As the Bible says, as iron sharpens iron, so one man sharpens his countenance on another. Disagreement is how we work towards the truth. And we will discuss it at another time. So let me look at a couple other questions here. Let's see. I keep trying to block them. Settings. Okay, not sure, Scott. Not sure what you're talking about here. It says you're trying to block them in settings. Not quite sure. Let's see. Roof curtains. Should 230 be repealed? That's on topic, because that's one of they talk about Section 230 of the Communications Decency Act, which is, to me, it's a classic example of taking a relatively simple task, giving it to a politician, and having them make an absolute mess out of it. So for those of you who are unaware, there's a federal law called the Communications Decency Act. It has to do because communications crosses state lines. So, commerce, and it's iffy, but it's there. Now, under Section 230, what any entity defined as a platform is, and I'm not going to be able to quote it off the top of my head, but you are protected from liability if you remove content that is considered obscene. There's a whole list of things, and the last entry is or otherwise objectionable. which is where the problem is, right? So if we get rid of all of Section 230, I think you're going to see content restricted even more, because again, let's put ourselves in Mark Zuckerberg's shoes, right? Let's pretend we're Facebook, and now if someone posts something, let's say somebody posts something offensive, and a bunch of moms find out their kids saw it, and they're going to sue Facebook, and Facebook has no protection. They're going to want to actually, I got to rephrase that, because it's protection from removal. So let's say somebody posts something obscene, and Facebook decides to remove it because they don't think their customers want to see obscene material. Now the creator of that may sue them for some reason. Hey, you're discriminating against me. You're based on this, that, or the other thing. They have no legal protections. So they're more likely to say, you know what, we'll just restrict a whole bunch of content because of this. Because the problem isn't with Section 230. It's with that one piece of Section 230. Now, again, we have to go back a little bit. Who remembers a few years ago, some kid live streamed on Facebook his suicide? Anybody remember that? And a bunch of people got up in arms, and they thought it was really terrible. And they all went to their congressman and said, you need to do something to tell Facebook this can't be done. Now, some people went to Facebook and said, listen, you really shouldn't have that. That's really kind of beyond the pale. But a lot of people went to government and said, you need to do this. So government says, fine, we'll write a law. We like doing that. They wrote a law, and this is okay. If you're a platform, which means you aren't the difference between platform and publisher is whether or not you control the content. They said, if you pull down content and it's obscene or it's, they had a whole list of things. But then they threw in this otherwise objectionable. Objectionable to who? All Congress really had to do is say, you cannot be prosecuted, you cannot be sued for removing content that either is illegal or promotes illegal activities. Now, if they had done that, suicide in most states is illegal. Facebook could have said, listen, yeah, if someone's going to broadcast a suicide, we can remove that because it's illegal. Or if someone were to post, okay, we're going to go to, this fat cat's house and we're going to burn his house down and lynch his family. Well, that's promoting an illegal activity. They could take that down. And if this group said, hey, wait, you're discriminating against me, we're going to file a lawsuit. No, we took it down because it was.
It could also be used as evidence.
Huh? Well, yeah.
It could also be used as evidence against them.
Again, but it's not Facebook's job to collect evidence in a crime, right? So they could look at that content and say, no, that's illegal. But instead they say otherwise objectionable. Now, I don't know why that got put in there. To me, the answer is not to repeal 230, is to amend 230 to just say you can, if the post either violates state or federal law, and united with if it violates federal law, if it condones or promotes the violation of federal law, boom, you're set. If you're getting into state law, though, that gets a little trickier, right? Because different states have different laws. So that might be a little trickier. You might want to go into it a little bit. And Daniel, I'm going to ask you to mute yourself because you're kicking. We're hearing you and you're kicking in. So yeah, it's not. It's not. Repeal of 230 isn't the answer to me. Fixing 230 is the answer. All right. So okay, Tunnel Lord's in here. Let me quote a part of the Federalist Paper 78 and break it down. The interpretation of laws of proper particular problems of the courts. What does it mean by interpretation? Okay, we're getting into, and Daniel, please mute yourself, because if I
have over here, it says tap to speak, and I've tapped it to shut it off.
Yeah, well, you're not but it's still open. There you go. Now you're muted. Okay. Again, Tunnel Lord, we're going down another path, and if we've got time, well, we don't have a lot of time, but what I'd recommend, if you want to go into this deeper, is to go to the website, constitutionsociety.com, search for Marbury versus Madison. I did a whole article on what the actual court said in Marbury versus Madison. To interpret the law for a court is to, well, all right, here, perfect example, all right? Let's say you play football, right? And let's say you're a ref in a football game. And you see an offensive lineman, the guy hikes the ball, the offensive lineman's defending, and you have to interpret the rule book to determine if what the offensive lineman did was holding or not, right? If you're going to, you can't just look at it and say, well, I thought he held. Based on what? No, you have to say the rule says he cannot grasp him, he cannot knock him down, whatever. With any of the rules in a game, the referee has to determine, they have to interpret what the rule means in order to apply it. The same thing in baseball, right? The strike zone is what? From the shoulders to the knees and the width of the plate. The umpire needs to interpret, okay, is it the knees and the shoulders, and is it over the width of the plate when he calls balls and strikes? That's what they're talking about. But what's interesting is judicial power, which is what's actually delegated to the courts, is the power to try specific controversies. So when a judge looks at a law and says, okay, if I interpret the Constitution and it says this, and this law violates it, the only power the judge has is to say, in this case, I award for that person, right? So if I bring a case and say, okay, Facebook violated something in the Constitution. Well, Facebook can't violate the Constitution. All right, the state of Tennessee. Let's say the state of Tennessee, they issue a state mask mandate, which they haven't, thankfully, and I take them to court. All the judge can look at and say, well, listen, this violated the Fifth Amendment, all right? You are infringing, you are denying him his liberty without due process of law. The only scope of that opinion is me in the state of Tennessee. Now, should other states look at that and say, I didn't think about that. That's probably a good idea. We probably should not do that. Yes, that's the way it's supposed to work. There is nothing in the Constitution that says the courts have the authority to overturn law.
What about the trial of law? Isn't the law supposed to be tried to find out if it violates the Constitution itself?
Show me one place in the Constitution where the Supreme Court is given final authority to determine if something is constitutional. You won't find it. I looked up judicial power. Judicial power is the power of trying individual cases. It's meant to determine controversies. So, great example, right? Texas has a controversy right now with Georgia, Pennsylvania, Michigan, and Wisconsin. So what did they do? They filed suit in the Supreme Court saying they have violated the Constitution. They have violated the agreement between the states that has impact on us because our electors for president may be overturned by someone who was illegally appointed as an elector. All the court can look at and say, okay, this is the facts, these are the evidence, this is the law. The law says that electors are appointed in a manner the legislature states. Let me pick on Pennsylvania because I've done some work on that. Pennsylvania has a law that says absentee ballots, mail-in ballots can only be accepted until 8 p.m. election day. This year was November 3rd. A judge ordered that it be extended 3 days. A secretary of the Commonwealth entered a consent decree saying we will accept them longer. The problem is the judge and the Secretary of the Commonwealth are not part of the legislature. They have no legal authority to determine the manner in appointing electors. So again, a judge can look at this and say, basically has to look at this and say, okay, Pennsylvania, did you usurp the authority of your state's legislature to determine the manner of selecting electors? Yes or no? If it is yes, then they can look at them and say, what they've done is illegal. They have violated the law, and then they have to come up with a remedy. That's a whole nother issue. Or they say, no, there is no evidence. There's insufficient evidence that they have done so. Sorry, Texas, you lose. What they don't have is the authority to go into Pennsylvania law and say, you must change your law to comply with what we think the Constitution means. Sorry, I needed some water. So let's see, where are we going here? Those laws mentioned, are those laws in reference to the rights of the Constitution or just in, again, the Constitution is law. Article 6, Section 2. I'm sorry, Article 6, Clause 2. It is the supreme law of the land. It is a contract that is a compact among states that establishes law. It establishes a set of laws that must be followed. It involves, but that involves regular laws, because the question is, the difference between the Constitution, federal law, state law is more a question of jurisdiction than the role of the courts. Tunnelor wants to talk about the Federalist Papers today. All right. If therefore belongs to them a certain thing, as well as the meaning of any particular proceeding. Oh, block the fact checker. So I'm sorry, Scott. I read that. I see that. They're getting conversations getting mixed up in here. Can tell us. Okay. So Tunnel Lord from Federalist 78. And by the way, I really don't like doing it this way because I like looking at these sentences in context. Very often you'll pick up context, but I think I know what you're asking, Tunnel Lord. The quote is, it therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. In other words, what does it mean? Their job is to determine what the legislative body meant when it wrote that law. That's why you have the context of, if there is ambiguity in the law, you go to whatever record of the intent of the drafter. Right? So in state law, it's why legislatures have to have a journal of all their proceedings. So when you look at the law or the Constitution and you're not sure 100% what it means, you can go back and say, well, this is what they were talking about. But back to your question, does it mean that judiciary can tell us where our rights end and begin? No. Right? Because they aren't, at that point, they're not interpreting they are reinterpreting the Constitution. Understand, the purpose of interpretation is to, in this case, is to apply what it says to the situation. Right? It is not to come up with some novel meaning. And I will give you a classic example, and some people may be upset, and I'm sorry, but I'll give you two perfect examples. One is the Roe v. Wade opinion, and the second is the Obergefell opinion. There is nothing in the Constitution that gives the federal government the authority to determine life and death issues within a state. They have no authority to determine medical issues. They have no authority to, there is not the legal crime of murder, the federal crime of murder is illegal. The federal government has no authority to punish murder because it's not a power delegated to them in the Constitution, right? So when you look at this, it's not for them to determine where it begins or ends. Is to apply. And here's the important point. One of the things, in fact, the next Thursday, I've got a video coming out talking about Oh, sorry. No, I'm thinking of the wrong one. Next Monday, I got too many videos in my head. Next Monday, I've got a video posting about the Bill of Rights, because Bill of Rights Day is Tuesday, right? It's December 15th. And in it, I talk about the fact that the courts have destroyed due process, because the courts have decided that the federal government can infringe on a right if they have a compelling government interest. The problem is that is not interpreting the Constitution, that's applying your own opinion to the Constitution. For example, the Constitution says, Congress shall make no law regarding an establishment of religion. Now, establishment has a defined English definition in the dictionary. You can go to the dictionary, and I like to go to the Webster's 1848, because Noah Webster was a founding father. It has a definition for establish. So when they interpret the Constitution, the question is, okay, did the government in this action create or make permanent a religious entity, organization, or practice? If the answer is yes, there's a problem. If the answer is no, there's no problem. They don't get to turn around and say, well, we get to decide what is okay and what isn't okay. Or put another way, let's see. Talked about this. I talk about this a lot lately. The Fifth Amendment says, nor shall a person be deprived of their right to life, liberty, or property, nor shall a person be deprived of life, liberty, or property without due process of law. Now, the courts, any court, by the way, looks at that and says, okay, the question I have is, what is due process? Due means owed. Process is a set of steps, the process of doing something, how you go about doing something. So is there a process that makes sure you get what you're due? In this case, we're talking about rights. So the question is there a process that protects your rights? In fact, the Free Legal Dictionary defines due process as a process, judicial or governmental, that ensures the rights of the individual. Now, there is not unless there's an emergency in there. The Constitution doesn't say that you're secure in your person's houses, papers, and effects unless there's a pandemic. So whenever the courts say, well, yeah, you have a right here, but the government has a compelling government interest, they aren't interpreting the Constitution. They are reinterpreting the Constitution. They're taking the plain language and twisting it to make something they want. That is one of the reasons, it's one of the biggest problems I have with the courts, is the fact that half of the amendments to the Bill of Rights protect our due process rights. And those are the rights that courts trample over and over and over and over again. Okay, let's see. If something is up for interpretation, then how can one entity determine when? All right. Again, the legal standard. You've got understand. You're dealing. I think part of the problem is we're using the word interpretation slightly differently. For example, I studied the Bible, right? Now, part of my Bible, the Bible wasn't written in English. It was written in Greek and Hebrew. So frequently what I'll do is if I'm studying something, is I'll go back to the best source I have for the original language, and I will try to interpret what it means in English, right? I want to translate it from English, from Greek to English, or from Hebrew to English. In this case, we're talking about interpreting from the law to the application, right? We're not trying to change what it means. We're not trying to redefine what the Constitution says. We're trying to figure out how to apply what the Constitution says. Interpretation does not change the meaning. Interpretation neither adds nor subtracts from the content that's there. It simply takes it and determines how to apply it either in another language or in a specific situation. So, that's part of the problem. So the ultimate, guess what? Again, the Constitution does not give the Supreme Court the authority to determine what the Constitution does and doesn't say, only to imply it to cases before them. Now,
but wouldn't the age of the Would the age of the dictionary make a difference in what some of those words mean? Because some
yes,
of the newer dictionaries have slightly different definitions.
which is why I go back to Webster's 1828, because it was written by a founding father. But to finish
They
off my
have
thought,
17. Okay.
to finish off my thought, right? The Constitution says the judicial power is vested in one Supreme Court and as many inferior courts as Congress seems to create. Judicial power, again, defined, is the process of determining controversies between parties. The limitation is the court has a limitation. I can only deal with the parties in front of me in this case. I cannot apply that opinion to another party. Judges do it all the time, even though it's not legal. It's actually bad behavior for them to do so. But our members in the legislature, probably most of them don't know what the Constitution says. If they've read it, it was decades ago. They don't have a clue what it means. They don't realize that it's their job to look at a judge who's behaving badly and remove them. But that's a little afield. The only people that have the authority to ultimately determine what the Constitution means are the states, because they are the parties to the contract that is the Constitution. Right? So if tell the Lord, if you and I enter into contract and we create Constitution book, just saying, and we create this company called Constitution Book, and we give it rules, right? You have a rule. You're going to exist here. You're going to run on this type of gear. You're going to allow this content. You're going to block that content. The employees of Constitution Book have no legal authority to change the rules. They're there to follow the rules. The example I hear often is, let's say you own a McDonald's or any burger joint, all right? And you hire somebody to be a burger flipper. So you hire this kid and he's flipping burgers, and he decides he doesn't want to flip burgers anymore. He decides he wants to be the fry guy. So what he does is he stops flipping burgers. He goes over to the fry station and says, no, I'm going to do this now. Wait a second. You set up the rules. You created that burger joint. You set the rules for the different departments. He's a burger flipper. When he walked from the burger flipper station to the French fry station, unless he had a really, really good reason, you'd fire him because he broke the rules. Well, it's the same thing with the federal government. The states created the federal government. They said all legislative power, all lawmaking power is vested in a Congress made up of a House of Representatives and Senate. All executive power is vested in a president, one person. And all judicial power is vested in one Supreme Court and in as many inferior courts as Congress deems to establish. So when you have a court that says, I don't like that law, and I'm going to overturn it, not because it's unconstitutional, it's because I don't like what it does. I don't think it meets with the Constitution. I don't think that you've got a problem. When you have a judge that says, well, yes, Mr. President, you have every legal authority to set this standard, but I don't like the way you did it, so we're going to overturn it. They are behaving badly. And according to Article 3, judges serve during good behavior. When they don't behave well, it is up to our employees in the House of Representatives to impeach them. And then the representatives of the states in the Senate try that impeachment and determine if it's A, is there evidence that this person has done what he's been charged with, he or she's been charged with, and B, does it really rise to warrant removal and banning from service in the federal government? That's the way it's supposed to work. But if you're going to determine what the Constitution means, that ultimately rests in the states, not within. You would not put final interpretation of the rules of a football game, of a baseball game, of a soccer game, of a volleyball game solely in the hands of the referee that you hired to do this job. You wouldn't, and neither did our founding fathers, right? The problem is we've been indoctrinated with this idea that the courts are the only ones that can interpret the Constitution, that the courts have final say on what is and is not constitutional. We've even had a president say, I think this law is unconstitutional, but I'm going to sign it and let the courts figure it out, right? As far as I'm concerned, he abdicated his responsibility. He was derelict in his duty. May not be a high crime, but certainly was a misdemeanor in its proper sense, by the way. Okay, let's see. Check out the article. Looking forward to meeting one of the current Black Robe. Oh, okay. So if you're not familiar, the Black Robe Regiment is what the British referred to the ministers in the colonies. When the colonies first became states, we talk about separation of church and state. It was actually many of the ministers that spoke out against what Great Britain was doing that actually encouraged the people to stand up to the tyranny, and they got nicknamed by the British as the Black Robe Regiment because they didn't. So many of them fought on the battlefield, but it was actually them that was a lot of the impetus, a lot of the spiritual backbone to the revolution. Let's see, Robert Carroll, can I explain how redress of grievances works in regard to laws made without the people wants or needs? Okay. There's a lot of ways. Okay, if you have a grievance, let's. All right, I want to get in the right mindset. I'm going to use the Declaration of Independence as an example because it lists 27 specific grievances the colonies had. So they had, you have military station in homes. You're protecting them with mock trial. You keep overturning our laws. You keep suspending our legislatures. These are each individual grievance, right? And they sent letters back for a decade or more to the king and to parliament saying, you're violating your own laws. Please fix it. So there are several ways you can look for a redress of grievance. Now, we often think of this as a grievance about a law, but we have to start with what is a grievance. So, for example, do I have a grievance against Facebook because of how they've treated me? Not a legal one. Well, the best I could come up with is a violation of license law, right? I had a license to use Facebook's platform, and the question is, did they violate a law or a right in how did they violate a law in the way they treated when they took my license away, right? I don't have a strong case there. But let's say I have a book, right? I have a book. I own the copyright on that book. Let's say one of you were just so enthusiastic about the book, you went out, you got it photocopied 1,000 times, and you began giving it away and selling it like crazy. I have a grievance against you. You've taken my property, the copyright I have in that book, and you've used it without my permission. Now, what's my answer? There's a reason why this is where I go to government. I say, I'm going to go to the courts and I'm going to sue you for a redress of my grievance. My grievance is you have violated my copyright. A, you've violated my copyright. B, you've profited from that violation. Therefore, I have grievances against you. I want to go to court to say, I want to sue you to, one, make you stop distributing my book, maybe get you to recall all the copies that you sold and gave away. I may ask for monetary damages because of the money you made from selling it, plus the money I lost from not being able to sell. But it's the government entity in the court that is where I petition for a redress of my grievance. Now, how does it work in regard to laws made without people's wants or needs? Let's start with what happens when someone passes when a government entity passes and makes a bad law. The first step is, well, I should go to my representatives and say, wait a second, you this is bad. Example, many years ago, back when I lived in New York, my House member, my member of the U.S. House, supported legislation that was blatantly unconstitutional. Right? I petitioned him saying, don't support this. It violates the Constitution here, here, and here. And oh, by the way, if you vote for this, you will be disqualified, in my mind, disqualified from office because you've violated your oath. You've violated your oath of office. You've gone back on your word. I can't trust you. Therefore, I'll have to work to find someone who can actually trust to take this office. I petitioned a representative for a redress of grievance. Now, maybe I take that to court, right? We have people suing against the lockdown shutdown orders. We have people suing with New York State. Governor Cuomo had an injunction placed against him for his rules regarding restrictions on churches and houses of worship. Those churches and houses of worship went to the court. The court said, well, this is still being worked out, but we're not going to let him enforce this until the courts figure out what the ultimate answer is, because we think you're going to win. By the way, if you heard that New York State lost a big deal in religious freedom, no, check out my article on it. But those entities went to a court, a government agency, for a redress of grievance. If my neighbor is trespassing on my property, if my neighbor is, I don't know, parking his car in my driveway every day, if my neighbor is whatever is doing that's violating my property rights, I'm going to call law enforcement, a government entity, to redress my grievance with my neighbor. Notice, at no point, with the exception of Cuomo, we haven't talked about a grievance against a government entity. The process is the same, right? So churches went against a government agency. You have several people suing different government actors with the election debacle. You even now have Texas suing other states for the election debacle. The point is, you have a right to ask government to come in and to petition government to help you get a redress, to get a solution to your grievance, whether that grievance be with a private party or a public party. There are a lot of different ways that could be done, right? Like I said, very often we think about courts. It's one of the main reasons we have courts, is to redress grievances between parties. You have controversies. A controversy basically stems out of a grievance, right? So I will take it to a government entity, a court, to deal with that. We tend to think of a lot of federal courts dealing with simply constitutional issues, which is a unique part of the role of the federal judiciary. But every time you deal with a legal action in court, you're petitioning the government for a redress of some grievance. So hopefully, Robert, that makes a little more sense. Let me go over here to the Zoom, see if I got any chat stuff in here. No, looks like that's going well. Let's see if we got any other questions in here. Looks like I got those. So it looks like I'm caught up with the questions. Okay. Before I close, I got some news for everybody. Some new stuff coming out. News number one. Next Tuesday is Bill of Rights Day. Starting that Monday, I'm going to have a new offer up on the website. You go to constitutionstudy.com. You will see an offer at the top of the page. It'll eventually be a widget on the side. You can sign up and get a free digital copy of my book, Read the Constitution in 30 Days. If you haven't read the Constitution, or you haven't done it lately, or you just can't seem to remember and find the time, you can get a book that will help you free. If you have a friend, a family member, a neighbor that says, well, I just don't have time. It's a couple minutes a day. I tried to write it like a devotional, right? So I've got 30 days, and in 30 days, you're going to read all the Declaration of Independence and all of the Constitution. And like I said, I don't have a copy of the book here. It's a 6x9 book. You open it up, 2 pages. I've got about a page and a half of the Constitution, and then a little bit of commentary. That's it. 2, maybe 3 minutes should be all you need to read that. And it's designed for those who've never read it before to take the Constitution in bite-sized chunks. For those who have read the Constitution before, as a good way to say, every so often, get in the habit of reading through it again, refreshing your memory, write it, remind yourself about it. It's designed to fulfill that requirement to read the Constitution. Now, John Jay says every member of the state ought to diligently read and study the Constitution. That's what this book is there for. And starting Monday, you can get it absolutely free just by registering on the website. So again, just go to constitutionstudy.com. You'll see it on the home page. It will eventually be in the sidebar with all the other widgets, but right now it's right there on the home page. Give that a try. Absolutely free. Now, what am I going to do about Facebook? Well, I have set up another Facebook account, but I'm not entirely sure what I'm going to do with it. And part of me thinks what I may do is just use it to look around. There are several groups I followed. There were several groups I would watch their posts. I would interact with a little bit, but not post to it. And I'm going to ask you guys for your input, right? So if you're, put a comment in, let me know. My other option is, what I think I might do is simply post excerpts and links for my posts. So in other words, when a post comes out on the website, well, go to my Facebook, my new Facebook home account will be kind of my little picture, a little excerpt, and a link back to my website with all the content on it. I'm done posting videos. I'm done putting in the time and effort to put that type of stuff on Facebook, but I'm thinking I might just have it post stuff that links back to my website. If you think that's a good idea, if you think it's a bad idea, let me know. That's what I want to think. But here's the interesting thing. And this third part isn't completely baked. You may have heard I have a membership program called the Constitution Scholar. I'm doing a remake of the Constitution Scholar. There are going to be several changes. Now, if you're already a scholar, don't worry. Everything you currently have as a scholar, you will keep. I'm not getting rid of anything. I'm just revamping the whole process. I'm going to use a new platform for it, and there's some neat features. So first of all, there's going to be a free version of the Constitution Scholar. Now, understand, the purpose of the Constitution Scholar program is for people who are interested in learning and studying and discussing the Constitution to have a place where they can get together and converse. I'm going to have walls for different groups within there. I'm still laying all that out. So kind of like a Facebook wall, right? There's going to be a group wall. So you'll be able to go in, and there will be different tiers of membership. So each one of those will have a wall. I'm thinking about setting up groups and walls for different topics. So I might have a First Amendment wall and a Second Amendment wall and a Fourth Amendment wall. So I'm thinking, not sure about that, still thinking about it. I might do one by state, right? So, we've got those Roof Koreans is in Maryland. I might set up one for your state. So other people in your state can discuss state issues related to the Constitution. There's going to be chat rooms, so that it's not just walls and posts. There'll be chat rooms. You can actually have your own chat room going on. I'm looking at, but I haven't decided yet. I might offer a messenger capability. I'm not sure about that yet. That might come later. I'm looking at other things I can do. But the two major changes that will impact you if you're currently a scholar. I'm setting up a whole new website, a new domain just for the Constitution Scholars. I haven't decided on a name because the name I want, constitutionscholar.com, is taken. So I'm trying to figure out what name I want to use. But there will be a new website, constitutionscholar.com or .org or whatever, when I figure that out. They will be cross-linked to the Constitution Study. But there's going to be a free version. So I'm going to create a new tier. I'm going to have a free tier. And probably the free tier will allow you a discussion board and some access to some of my free content and access to the new store. I'm redoing the online store as well. Then as you become a paid member, right? So there's going to be apprentice level, journeyman level, master level paid versions. As you go up in the paid versions, you'll get access to more content. So right now, everything that's in the library today at the Constitution Scholar will be available at the apprentice level in the new system, which hopefully I'll have, if not by the first of the year, early next year. Right? I want this to be really cool because I really want a place that for that open discussion where Daniel, where you and I could get onto a chat room or a board and we can discuss this back and forth and allow others to follow along and have a true open discussion. We may not come to agreement, but we should be able to have a good, open, fair discussion, where we can share information, maybe even share news about events. So, if I'm going to be at a specific location, we'll have those events. If there are, if your town or your state or your city is having a Constitution event that you want to let everybody know about, I may have that in there. That's part of what's coming for early next year. No matter where else I am, Rumble, Parler, YouTube, Facebook, Twitter, MeWe, wherever, the home is going to be the Constitution Study and the Constitution Scholar. They'll be linked, right? So you don't have to worry, do I one or the other? But that's going to be the home of actual online Constitution studies. I'm going to be working with Institute on the Constitution so that you'll have access to their free classes. You'll be able to get them through the program. You'll be able to become a member of the IOTC if you want to. I'm working with the 917 Society. We want to help. They're trying to get constitutions in the hands of every 8th grader on Constitution Day every year. So we'll have information about that in there. That's my plan. Rather than doing all this stuff on Facebook is now and YouTube, I want them to be feeders into the Constitution study. So I hope that sounds interesting to you. I hope that sounds, well, it looks like Daniel left us. I'm sorry to hear that. I hope that's interesting to you. I hope you find that exciting. Part of me finds it, I find it rather exciting. I'm thinking, I started doing more of these live streams because I wanted the interaction. By the way, the live streams are available on the website. All right. So I got a lot of people on Facebook that were watching me, and I'm trying to drive them now to the website. They will always be available on the website. So let me know. What do you think? Do you think MeWe is a good choice or not? Should I bother putting time and effort into there? Do you have any suggestions for the Constitution Scholar? The free book is there. Again, it's designed so you can get a copy, but you can also, if you would, I would appreciate it if you have somebody you think would really benefit from that book, please send them the link when it posts on Monday. Just send them a link, have them register. It helps me know who's actually interested in what's going on. It also helps me put some context if someone comes back with a question, right? Because part of what may happen is I may actually link that registration to the follow-up questions, right? So when someone, if they have a question, I can link it to, oh, well, this person's done this, and it helps me understand what's going on. Again, the comments will remain open. So if you don't get to it now, I will look at them. I will look at them later. But I appreciate everybody taking the time. I appreciate people suffering through my initial technical difficulties. Please share the word, share the message. Let people know there's a place they can go to get, I believe, accurate information, but they can always fact check. I don't mind if individuals fact check me. There's a reason why all of my articles have hyperlinked quotes. I quote something, I have a link to where I found it so that you can go and double check me. Let's spread the word of a place where we can learn about the Constitution, where we can help each other. There's a great video. Last week I had it about the restaurant in Buffalo where code enforcement and the sheriff's deputy showed up to shut him down. And when the owner stood up to stand against this tyranny, the people came in support of him. I want the Constitution study to be a place where we can do that, where we can get together, we can know what our rights are, we can know when they're being violated, where we can prepare to defend and assert them, and most of all, where we can prepare to help our neighbors and our friends and our family defend their rights as well. Let us not try and stand alone. Let us all hang together, because that's what it's going to take if we're going to maintain rights and liberties in America. Yep. And scary friend, you're right. The vast majority are on Facebook, but I'm hearing more and more people are leaving Facebook. They're getting tired of the censorship. They're getting tired of the ham-handedness with which they're dealing with content. And the trick, I think, is going to be finding a way for people to leave Facebook, or at least not depend on Facebook, but still get access to other information. And I'm trying to work with a group that may have an idea about that. I can't tell you about it, but I know there are people working on what happens as people begin to wander away from Facebook, or at least supplement Facebook with something else. Anyway, thank you for your time. Thank you for your attention. Please like, share, discuss, and hopefully, by the way, Thursday's live stream will not be, the fourth Thursday's live stream is Christmas Eve. So I didn't figure people want to be talking about the Constitution on Christmas Eve. So there won't be one until the second Thursday in January. So you've got a couple of weeks off, but I'll still be posting videos. I just won't be doing live streams. But hopefully, in any case, you'll come back. We'll meet you again at the Constitution study, and we'll have a wonderful discussion. Thanks, everyone.